Okay, we are streaming. Resuming, so presentation. Okay.
Text out there, waiting room. Who does it? I am. Yeah. I am.
Yep.
This is Jay. Oh, apparently they put in J.A.
Somebody got their fingers going too fast.
Yeah.
Okay, anytime you're ready.
All right. Can you hear me, Ms. Henry?
Yes, we can.
All right. This is case number 210100. State of Ohio versus Brittany and Henry. Henry is appearing by Zoom from the jail. Her attorney, Linda Kirk, is present by Zoom in his office. Mr. King appearing on behalf of the state on Zoom as well. So, Commissioner Officer Bolton is present. This is a pre-trial. The defendant is charged with aggravated trafficking and methamphetamine aggravated possession and a torture specification. And this is the first pre-trial, final pre-trial set on the 21st of July, and trial date is set on August 9th. I see that I know Mr. Armstrong was originally on this case and had to withdraw, and Mr. Kirk was appointed replacement. See, Mr. Kirk, you did get discovered that, it looks like, on the 15th of June.
I did, Your Honor.
All right. And so we're also bill particularly provided. Mr. Armstrong requested that.
I have not seen that from Mr. Armstrong yet.
It is in file, so did you get Mr. Armstrong's file? It's filed on June 8th.
I'm not sure where the discovery came from, but I did get it in my box, but I have not seen the bill of particulars, but I'll get with Mr. Armstrong.
Yeah, where did you get it from the clerk? Right. It was filed on June 8th. All right. So defense discovery will be due by the final pre-trial. Do you anticipate any pre-trial motions, Mr. Kirk?
Not at this time.
Right. And was there a written plea offer provided with the discovery?
There was, and I did relay that to my client.
Okay. Are there any other matters then that need to be discussed at this point?
Yes, sir. I would have asked the court to review the bond in this matter. I do not have documentation of what that is, but these appear to be my client's first felonies, and would ask the court to consider no more bond or a reduction in bond.
All right. Mr. Okay, I did reduce the bond originally from 20,000 to 10,000 on June 9th, so after a bail review period. So, Mr. Kane, do you have anything you'd like to say?
Your Honor, given that the bond has already been reduced once from 20,000 to 10,000, it's the state's position that this bond is appropriate. Charge in this case is obviously very serious, carries mandatory prison time, so it's the state's position that the $10,000 bond is appropriate.
I think the bond, I'll leave the bond in place at this point. This is a mandatory sentence on a second degree crime. All right, anything further?
No, Your Honor.
All right, thank you. All right,
8:45.
8:45 will be this
Tanya Woods
notification.
in person.
So she appears. Is 8:44. You heard anything from her? Eric? No. That's a shame here. Case number 20-CR-006, State of Ohio versus Tanya Michelle Woods. This is a hearing on a motion filed by the state to close intervention in lieu of conviction. Mr. Argino, probation department here. The motion was filed on 6/2/21. Court sent notice to the last known address. Court will note that the defendant, according to the motion, failed to report since March 4th, has not been compliant with the treatment plan with Rio. And Mr. Argino, have you heard anything from this since filing the motion?
No, nothing to talk about.
All right, the court then will order Kate this issue, and she is taken custody, then will bring her before the court. Thank you. Okay.
We have Joshua Nisley sentencing by Zoom, as well as this Ray.
I wanted to get us a, do the hearing, Mr. Ray first.
Okay.
He's here. Go ahead and contact him. Okay, Ms. Barber, you're muted there. All right, this is case number 21-CR-52, State of Ohio versus Joshua M. Nisley. And case number 21-CR-14 and 21-CR-66, both State of Ohio versus Joshua Nisley. And this matter is being conducted by Zoom, and you are Joshua Nisley, appearing there from the jail. I can't hear you.
Yes.
Okay, there you go. All right. You can tell David that All right, and this attorney is Sarah Barber. She is appearing by Zoom as well as Assistant Prosecutor King on behalf of the state. We also have our representative of the information department on the call. And Ms. Barber, you and your client both agreed to conducting this matter by Zoom rather than in-person hearing.
Yes, Your Honor.
You all right with that, Mr. Nicely?
Yes, Your Honor.
All right, thank you. All right, the defendant has entered a plea of guilty in 21 CR 14 to aggravated possession of methamphetamine, and in 21 CR 66 to fail to comply with the order signal of the police officer. The court ordered a pre-sentence investigation. I have received that and reviewed the same. He was also referred to the drug court for evaluation. He's been evaluated, and I do have a letter from Ms. Sturgill, one of the probation department representatives, indicating that he meets the criteria, clinical criteria for admission, and legal criteria, and also Mr. Nicely, there's a death available for him at STAR that the court grants him in control on July 7th. All right, anything from the state regarding sentencing?
Only what's contained in the plea agreement, Your Honor.
All right, Ms. Barber, on behalf of the defendant.
Just what's contained in the plea agreement, Your Honor.
All right, Mr. Nicely, anything you would like to say?
Yes, Your Honor. I really need this chance to, change my life around, not only for me, for my kids and the community. I really would like to rehabilitate into a positive, productive member of society that I have not been before. I'd really like to change my life around and do that.
All right. Anything else you'd like to say?
That would be it.
Okay, well, Mr. Nicely, the thing about drug court is that the court does not order people into drug court. It accepts their applications. You have to apply, and you sign the program, acknowledgement of the program requirements and restrictions. Do you understand what this means if I push you into drug court, about how intensive it will be, and what should be expected to do?
Yes, Your Honor.
I mean, it's much more intensive and difficult than regular community control. In that once you get through treatments, you'll be expected to be in probably a transitional housing. Once you get done with your STAR program, because STAR is not an actual treatment facility, that CBCS offers some training and classes on that, but it's not the core program. And so once people get done with STAR, it's usually basically getting them where their brains are cleared and their bodies are, recovered from the long-term substance use disorder, and then you become more amenable to treatment, and you probably go into a treatment facility after that, such as a counseling center or youth reentry or something like that. And you'd be expected to be drug tested, be subject to be drug tested every day. You'll be tested certainly 3 or 4 times a week in the first phase. Minimum of 18 months, and probably for someone like me, probably closer to 2 years, depending on how you do, if you're admitted. And it depends on your intention. If your intention is simply to try to avoid going back to prison, you're probably not going to be successful. Because community control conditions are basically, we're trying to keep people out of prison and hopefully help them along the way, but it's not as intensive. The focus of drug court is to focus on getting sober, staying sober, and rebuilding your life. And if you do all those things, then it's much less likely that you're going to commit another offense and go to prison. But it has to be on sobriety, and it has to be sincere. And I'm going to tell you the first thing is honesty. Is if you're just saying, and even if you're saying to yourself, well, I'm ready for this, again, if you're lying to yourself, you're just lying to everybody else. So this is something that you have to want to do. And Is this, are you certain this is what you want?
Absolutely.
Well, you are a high-risk offender, and you have quite a history, but not much in the way of treatment. And so based on that, the court is going to accept you, does accept you into the drug court docket, and I am going to, in each case, order that you be put on control for a period of 3 years under these conditions. First, you'll be required to comply with all of the conditions of the program that you have signed and are filed with the court in the files and are incorporated as part of those conditions. You're to obey all laws, all jurisdictions, conduct yourself in a law-abiding manner at all times. Must report when and as directed. Be truthful in all statements you make to the probation department. You must keep them informed of your residence and place of employment at all times and may not change either without prior permission. You're not permitted to leave the state of Ohio at any time without prior permission. You may not enter on the ground of a correctional facility or may communicate with or attempt to communicate with anyone who is an inmate in those facilities without prior permission. Because of your conviction for the drug offense and probably past convictions, you're not eligible to purchase, possess, use, or have under control any firearm, ammunition, or dangerous ordnance. That's the condition of your community control in this case as well, and not permitted to have any other type of weapons either. You're not permitted to purchase, possess, use, or have under control any kind of controlled substance, drug abuse, or any CBD oil, kratom, or other variant or analog of any controlled substance, drug abuse that has effects similar to controlled substances and drug abuse, or any other instrument, device, or thing that may be used to administer them for prepared administration unless you have lawful copy or a lawful prescription, copy of which must be provided to your supervising officer within 24 hours of receipt. You're also not permitted to obtain a medical marijuana card. That seems to be a big thing now with people on probation as well. You can't get high illegally up to get a medical marijuana card to chill out. Well, that interferes with people's treatment. It's just another way of self-medicating. That's why you can't have alcohol, which I'm going to tell you about in just a minute. So that's so you can't do that, and you are required to submit drug testing when and as requested by the probation department or your treatment. And it may be you'll be tested both ways. You start reporting, or the officer comes to see you, maybe be tested then as well as at the treatment facility. Now, you're not permitted to purchase, possess, use, or have under your control any kind of alcoholic beverage, or may be present in places of the soul being consumed with unwashed water. Again, it's the same thing. You can turn to alcohol or marijuana or CBD oil or etc. as an alternative. You're not to associate with anyone who is a co-defendant or any person that has criminal records, member of gang, or member of group, or any person that has past or future exposure to commit a criminal offense to violate these conditions, unless that's approved in writing by your supervising officer. That applies to any family members that might fall within that definition, unless you were living with them immediately before the commission of these offenses. After the date of this order, you're not permitted to marry or establish cohabitation or common law marriage type relationship with another person without written permission. You must report any time you come in contact with law enforcement, any arrest, citation, conviction, or other charge of violating the law not later than the next business day after that occurs. You must provide your supervising officer financial information records so your ability to pay any restitution fees and costs to be reviewed. If you are referred by either the probation officer or any other probation employee, treatment team, or any further evaluation or assessment, any kind of treatment, therapy, counseling, training, or educational program, you submit to that. If it's recommended that you undergo that programming, you are required to enroll in and successfully complete that. They're paid court costs and maintain arrangements with the clerk. Now, you'll remain in the Huntington County Jail until you convey to STAR on July 7th. You'll be required to comply with all conditions of your treatment plan. And right now that includes STAR, and then ultimately most likely into a transitional program, and from there maybe sober living, but whatever the treatment team is recommending, that's what you'll be required to do. Now, once you get out of CBCF, the STAR program is a lockdown facility. If you go to these other facilities, they're not lockdown, and they can't make you do something against your will. If they tell you should do it, they can't make you. Well, I can't. And you will. If the treatment team tells you you should do it, then that's what you should do. Because your decision making has not been good for years, and it's going to take a while for it to get to the point where the court and the treatment team are going to trust your judgment. Now, by being placed on community control, rather than being sentenced to prison, you're deemed to be consented to search without a warrant of your person, residence, vehicles owned by you, used by you, or any other property or places under your control where you're found anytime by any officer of the probation department. There will be no fine imposed. In either case, there will be no fine or suspension imposed in the 21 CR 14 case, aggravated possession of methamphetamine. In the 21 CR 66 case, there is a mandatory license suspension of at least 3 years, and the court ordered that be the suspension, and that begins today. And the court is permitted to grant limited gravity privileges if you have proof of financial responsibility and you're otherwise legal to drive in any other courts. Now, you're also to pay court costs of the substantive order, and if you don't make any arrangements and comply with that, the court can order you to be serviced, give you credit for each hour you work, and under set by the court, each hour you work, reduce your judgment by that amount until paid in full. Now, in the event that you fail to comply with these conditions, the probation department will file a notice of that with the court in writing, and you get a copy of that. You'll be entitled to have a hearing to be represented by counsel. If the outcome of the hearing is that you have failed to comply, at that time the court will revoke your control, terminate you from the drug court office, and sentence you to prison at page 21 CR 14 to a term of 12 months and fine you $2,500. And in 21 CR 66, fine you or imprison you for a period of 36 months and fine you $10,000. If that happens, on completion of the prison term, 21 CR 66 is mandatory to be put on post-release control supervision for 3 full years. It's optional in the 14 case, but it's mandatory in the other, so it will happen. That means you'll be supervised by a parole officer on terms of parole 46, and if they determine that you failed to comply, then they can return you to prison, even though you serve the entire term set by the court for an additional period of up to 9 months for any one violation, up to the maximum half of your prison term for all violations. But if it's a felony, then an additional whatever sentence the judge in new case imposed upon you, the judge can also sentence you to an additional term of incarceration for committing the offense while under post-release control. In this case, or in these cases, for an additional period of 1 year or time is left on that period of post-release control supervision, whichever is greater. That occurs, that must be served consecutively with the sentence in the case. All right, is there anything further from counsel?
No, Your Honor.
No, Your Honor.
All right, Mr. Nicely, you'll be held in jail. They'll be picking you up then on the 7th to take you to Scott.
Thank you.
Thank you.
Thank you.
All right, Mr. King, you and Mr. Wagner need to be here in court. We have Mr. Ray, he's here.
Yes, sir.
Thank you. See how Josh does the challenge.
Yeah.
Is Mr. Ray here?
Yeah, he's sitting there with Scott.
All right.
He does.
Out those ways.
All right, Mr. Ray. I say the one I'm keeping my eye on scares me with Notre Dame as well. Is that Sonny Styles out of Pickerington?
Yeah,
His brother's already there.
yeah. Lorenzo's his dad, but his brother's at Notre Dame. Yeah, he'll go there.
I think he'll be,
I don't think he'll get it.
I think he'll be a good one.
Yeah, it would be good.
Yeah.
Okay, all right. Email that and ask about it.
Well, and I-
Or leave the right issue.
Yeah, I know, she said, she said, if the person has any problems,
So any one of those X's or when you're up there by the desk. That's your.
Right here.
The way that email was here, that racial folder. Nice.
Get cell phone on
That's
that.
one, and then we'll go to that.
You been vaccinated? The sign-in sheet is Just in case anybody comes down with it, the health department knows where to start.
Still only at 30% vaccination. Unbelievable.
Yeah, did you see how the 80s are pretty good, 70s, 60s, get down to the young ones, 4%.
Yeah. Also, that happens, some of them have to die. Well, it's get certified, but on the other hand, regular COVID, they wasn't that bad, so that's what I advise, that's what we do here.
Saw a kid dropped over dead in Princeton at soccer practice, and I wondered if he had it.
Now they had a heart condition. Most of the time, those kids die in high school or college, they have a diagnosed heart issue.
Well, that's what they were wanting to do several years ago, expand the required physical to include heart study, and they said, nobody will be able to afford to go see
We can't. This thing's not cheap. Yeah, schools can't write costs back doctor. All the hospitals. I mean, again, those are so rare. Never lost anything. You look at the number of kids playing, and those conditions, those things always get a lot of publicity because it's tragedy. And someone dies, but it's relatively rare.
It is, and
They actually have a better chance of not COVID.
on the record for Ray. Note sheet.
It is case number 21 CR 52, State of Ohio versus Melvin D. Gray, present for the state assistant prosecutor King, present for the defendant is Attorney Jacob Wagner. And are you Melvin D. Gray?
Second, yes.
The second? Okay, I see that's on the header of the jacket, but the indictment just has Melvin D. Gray. But it is the second?
Yes, sir.
All right, there's no objection to amending that, is there?
Yeah.
So we're going to add to the face of the indictment so that put my initials in the date so it's clear on that. All right. The defendant is charged with a felonious assault, a second-degree felony. This is a hearing on the report from the Forensic Evaluation Center, which the defendant is referred for an evaluation regarding his mental status. The court did receive the report and reviewed that. Each of the attorneys received a copy of the report. State that.
Fantastic.
Does either party wish to present any evidence beyond that that's already contained in the report? Nothing. State.
Nothing to defense, Your Honor.
Okay. The report was with Dr. Angela Ledgerwood, psychologist. The date of the evaluation was the 26th of May. The report was dated the 21st of June. She has raised the opinion that at this time, Mr. Ray is not competent to stand trial due to his mental condition, and recommends that he be found not competent. And she does further reply that he could be restored if afforded a course of treatment in 1 year, which is the statutory period for second-degree felony. And she further states that it appears that he has established relationship with psychiatric provides maintenance treatment. It does have transportation, stable housing, support of family members, and has reported medication compliance. And so it's her opinion that the least restrictive setting would be an outpatient restoration treatment through Twin Valley Behavioral Health Care, and if not, then residential treatment. Now, I was just talking with Mrs. Boyer during break, and I had a discussion with Mr. Wagner about the time. And she just got an email this morning, said it is still, about a 90-day wait for residential, restoration. But that, outpatient would be much quicker. And, but again, that would depend on, the, defendant parent, as required. I can't tell you what that is, but yes, it's at least a couple times a week at Twin Valley in Columbus. Mr. Wagner is your client, if we talked to him about that, is he able to guarantee that he will be able to attend, that we'll get to those sessions and comply with those sessions?
Yes, sir, Your Honor. Mr. Melvin, does have, transportation, he'll be able to get there. Obviously, he has the support of his father. He's been at every court hearing that I've been involved in, from municipal court to now. So he does have a strong support group. So, again, obviously, we would honor or ask the court for the outpatient avenue first, Your Honor.
Mr. Ray, are you driving yourself, or does your father or other family members transport you?
I drive myself.
You are able to drive? Okay. And are you keeping your own appointments, or your family help you with that? And are you living with your parents?
My mom is deceased, but I live with my dad.
Okay, you are Mr. Ray's father? Alright. And so, are you available to help make sure that he tracks his appointments and gets there?
I work, I have to take off.
Well, he can drive himself, just making sure he does go and get back, because if he doesn't show up for the treatment, and it could be more than a couple times a week, I don't know. When somebody's in an institution, thankfully they work with them every day, but when they're on an outpatient basis, I think it may be, they'll work a little longer with them, but it'll be, less than every day, more like, I'm going to guess 2 or 3 times a week. I mean, you have to drive up there. But you're capable of doing that. He said he's doing that himself now.
I need a GPS or something if he has to go to Columbus.
Okay.
Yeah. I lost it.
Well, I understand that. It's not hard. That's one of the things about GPS and phones. And I use my map on my phone all the time, so you use the map anymore. So, all right. Well, here's what I'm going to do. Mr. Ray, the finding of the court is that you're not able to assist in your own defense at this point, or understand the nature of these proceedings, and objective proceedings, that there is substantial likelihood that if you go through this additional treatment and maintain your existing treatment, your psychiatrist and counselors, that you can be restored. And so I'm not going to order you to be put into the residential program up there, because that's basically a lockdown facility, and you will be up there could be up to a year. Or until they determine that you have been restored to competence. This is the first time I've done it this way, but because of what's happened now, because of COVID and quarantines and the problems they had in institutions, they're way behind getting people there. As I mentioned, it might be 90 days if I order you with that. So I'm going to allow you to do this outpatient. You'll be required to they'll contact you or your attorney to set up your first visit, and maybe your father or somebody can take you there first visit so you get familiar with it, and then after that they'll give you an appointment schedule. You'll be required to go to each of those sessions and to cooperate with them, and you're also required to stay compliant with your medical. Take your meds, or you are on medicine.
Yes.
You're required to take your medicine as directed, and to comply with any other treatment that your family doctor or the family psychiatrist, the person that you're getting your medicines from and doing your counseling with, you need to continue to comply with that treatment. So you don't go up there in place of your current doctor. It's in addition, so you're going to do both. You still have to see your doctor for your regular appointments and medical assessments and any counseling that he provides or he or she provides, as well as any therapy sessions, groups, etc. And then in addition, you have to do this. It will be a little bit inconvenient, but I can tell you it's a lot better to be in a lockup facility for maybe a year. And so, this is a way to avoid that, because you have to stay compliant. If we're told that you're not compliant, then what will happen is there'll be a warrant issued for your arrest. You can take you to jail and then conveyed up there and for the duration of the term, until they either feel that you're competent to stand trial or that you can't be restored, at which time there would be other potential commitment proceedings that could result in a commitment to the facility, treatment facility. All right. Do you have any questions, Mr. Ray? How about you, Mr. Ray's father? Do you have any questions? Okay, well, again, I don't expect you to take off work every day, but you have to get treatment maybe the first time or two. And then, make sure he just remembers his appointments and gets there. Make sure you bring back proof, that you've been there for your dad and your attorney. In case they say, sometimes, there's a big bureaucracy and things can get lost. It's always best if you try to have some verification that you're there. Maybe a parking ticket or something that they don't give you. They'll probably give you something. They may give you materials to work on. How to do an application. I've not ever had this happen before in my career. It's always been inpatient. So we see the results at the end. We don't see it while the person is out going back and forth. All right. Anything further, counsel?
There.
All right. So there won't be any further court proceedings until the court proceeding report. This will be ongoing for a period of up to 1 year from today. If they do decide that you're restored, then come back and the case will be reactivated. And decide you cannot be restored, as I said, then that time the court will have a hearing and make a determination of what should happen for that, which could involve a future commitment, but that's remains to be seen and with certain things. All right, thank you, counsel.
I have a question, I apologize.
Sure.
Procedurally, I don't even, the court may have vacated that pretrial supervision.
He's off that now.
Okay, and then should he just report to the initial consultation? I mean, I want to get him on the right path.
I'm glad you brought that up. Since the case is now inactive, the pretrial supervision and the bail is not applicable. Let me back up. It is applicable in that you do still have to comply with the order of the court, which is set reporting probation. Being under pretrial supervision is that you comply with the treatment plan, restoration treatment plan, plus your regular plan. So that's kind of what your pretrial supervision is. So you're not going to have to report to probation, on a regular basis.
Say report to Twin Valley and set up a schedule. Okay.
Yeah, well, I have the Forensic Evaluation Center, Dr. O'Donnell, and her name is Jane O'Donnell. She's a director. She's also a doctor, psychologist, and she has volunteered to coordinate placement because they work with them on a regular basis. We've been having a real problem with getting people in because they're so overwhelmed. There's not very many facilities in Central Ohio that offer this service. And so, and again, they're way below, they were under capacity for a year because of COVID. And just now trying to catch up. And so, have you had a vaccination?
Yes, sir.
Okay, I would say, because that's probably one requirement that they have to be in this program. And, if you didn't, I know there's a judge up in Franklin County, Texas, brief over requiring probationers to get it, but for this kind of thing, you don't have to have it. So you probably want to take a copy of your vaccination to show it because, that's one of the things that's happening. They're taking people up there, they quarantine them, and they've happened if they had it or they get the vaccination and then they have to, still be quarantined. So, that'll make it a lot easier to get you in, I think. I think they'll take it. But yeah, thanks for bringing that up. Okay. So inactive, no pretrial supervision, apply with outpatient treatment at Lynn Valley Behavioral Health Center and treating psychiatrist. And if you quit complying with any of those, then, like I said, I would have you picked up with jail. Make sure you make your appointments and keep on that. So don't do that. So it seems like you're stable. We want to see you stay that way. All right. Anything else?
No, sir.
All right. Thank you.
Thank you, Your Honor.
All right. Next one's 10:30.
10, Your Honor.
10. Okay, case number 21, CR 51, State of Sarah Bay Dixon. We're going to have the state's assistant prosecutor King. We're going to have the defendant's attorney Catherine Hacker. And are you Sarah Bay Dixon?
Yes, sir.
Ms. Dixon is charged with 2 counts: illegal conveyance of drugs and abuse under the grounds of a specified governmental facility, a 3rd-degree felony, and aggravated possession of a 5th-degree felony. The defendant filed a motion for intervention with conviction. The court did order a report of the probation department, and I received that along with confirmation that Ms. Dixon is in treatment at Southern Valley Mental Health Center. And in case she, in fact, received yesterday, in case she had been in attendance, or I would be participating fully in the program. Now, as far as the report indicated, they felt she was eligible other than on count 1 with the resolution she pleaded count 2. And so, the court has been presented with the plea of guilty form, which indicates Ms. Dixon should going to plead guilty in exchange for being placed into the intervention legal conviction program. Now, and we may have talked about this before, but I have to go over it on the record again, just to make sure you understand. Normally, when somebody is convicted of a felony, whether it be through a plea, guilty, or by a trial, and that person is sentenced, it can be a prison term, it can be controlled probation, it can be a fine, or in this case, a suspension of license, or a combination of those. And then that means that the person does have a felony conviction. Now, the procedure that's been proposed that you go through, called intervention legal conviction, allows the person to plead guilty to an offense that's eligible for this program, but not be found guilty. And the way that works is you file your guilty plea and make the plea guilty. Instead of finding you guilty, the court stays proceedings, and the stay basically means stop and freeze. And then you are put into a reporting program with the probation department under supervision that's less strict than you've been convicted. And also you're required to complete an intervention plan. And part of that also is that you must refrain from using any alcohol or drugs other than those that have been lawfully prescribed to you for a period of at least 1 year. And I normally put people into this program for 2. They can be in for up to 5, but I put them in for 2. And then I wait to hear from the probation department as to how you have progressed in the program. And if you comply with your treatment plan and all the other conditions, then at the end of 2 years or possibly earlier, depending upon how you've done, the court dismisses the charge even though you pled guilty. Because what will happen is the plea of guilty will be in the file, but there will be no finding. So if somebody says, well, you pled guilty, you can say, yeah, but I haven't found guilty because I'm in treatment. And if you successfully complete the program, comply with the conditions of supervision, and comply with your treatment plan, then the court dismisses the charge even though you pled guilty. Then I have a hearing, and unless something happens between the time of the dismissal and the time of that hearing, then the record gets sealed. And from that point on, you can tell people that you do not have a felony conviction, and you can answer that way, you'll be telling the truth, and it won't be on the record. It'll take about 30 to 45 days for everything to be sealed by the various agencies that we have to send that notice to. But you will, you'll get a copy of the entry which says that your case was dismissed and you don't have a record. So that's a big advantage. Now, the disadvantage is that if you fail to comply with the treatment program, use substances illegally within that 1 year period, or even after if you're still in the program, or if you stop reporting, stop going to treatment and take off. Then when they're brought back before the court, at that point, then you're found guilty because you've already pled guilty. You had your chance for trial. You don't get to go through the program, then come back and say, well, since it didn't work out, now I want to try this case with I don't want to be found guilty. It's too late. So that's the downside. So, do you have any questions about that?
No, sir.
Okay. All right. Well, I have this form in front of me that says you're going to plead guilty, and this is I think this one's 4 pages. Yes, 4 pages long. And the prosecutor prepares this from a form that top of page 3. There's a statement. I entered this plea voluntarily. Right below that, there's a signature, and it appears to be Sarah Dixon. And then you'll see the attorney's signature. Did you sign this agreement
Yes, sir.
this morning? Or?
It's been a while.
That's right, we didn't have confirmation of treatment.
Correct.
Yeah, okay, so it's been some time.
Yeah.
All right. All right. Now, you understood when you signed it that this is an agreement to plead guilty, which means it won't be a trial. And the
Right.
next step would be going ahead and deciding what happened, which in this case would be 17 convicted and sentence would be placed in this program. You understand that?
Yes, sir.
And since it's been a while since you signed this, is this still what you want to do?
Yes, sir.
And are you agreeing to do this voluntarily?
Yes, sir.
Not been pressured and threatened in any way?
Not at all.
Right. Now, the agreement states you're going to plead guilty to count 2 of aggravated possession of methamphetamine under 29.5.11 of the Higher Vice Code of 53 felony, and that the maximum penalty for that should you be found guilty and sentenced could be 12 months in prison, and minimum would be 6 if prison was imposed. A fine of up to $2,500 and possible license suspension between 6 months and 5 years. You understand that?
Yes, sir.
And you're not facing any felony charges anywhere else? They had this before?
No.
Okay. And you're not on community control, parole, probation, or post-release control for a felony?
No.
Okay. Now, if you are placed into intervention and on community control for a 2-year period, if during that period of time probation feels that you have failed to comply, or treatment is not being complied with, they will file written notice at the court. You'll have a hearing. You'll be represented by counsel. And if the outcome of that hearing is that you have failed to comply, then at that time you'll be terminated from the intervention program. You will be found guilty, and then you'll be subject to a sentence. And if that happened, that could be a sentence of between 6 to 12 months in prison. If that, in addition to that sentence, once you completed the sentence, the law provides that the adult parole authority may choose at their option to put a person under post-release control supervision for up to 3 years. They don't have to, but they can. But they do be supervised on the conditions they set, because of course I'm involved with that. And if they determine that you failed to comply, then they can return you to prison to serve additional period up to half of whatever prison term is imposed by the court for 1 or more violations. But if you committed a felony involving post-release control, then in addition to whatever sentence the judge in the new case can impose upon you, that judge can also sentence you, in this case, for committing that offense while under post-release control supervision to an additional period of 1 year, or whatever time is left on the 3 years of post-release control, whichever it is greater. And if that happened, that would have to be served consecutively to the sentence in the case. You understand that?
Yes, sir.
Now, even if you fail to plead and are found guilty, the court does not have to sentence you to prison at that time. It would still be up to the court to determine whether you should be sent to prison or be put under community control supervision. Community control supervision is much more strict than the community control for this program, but it could be for up to 5 years. And it would work basically the same in that if you were alleged to have failed to comply, then the probation department would file written notice of that, have a hearing, be entitled to have counsel, and if the outcome of that hearing was that you failed to comply, then the court would revoke your community control and then send you to prison for 6 to 12 months, fine you $25,000. You understand that?
Yes, sir.
I also mentioned that there is also a license suspension possible. That's 6 months to 5 years. All right. Now, the charge in count 2 alleges that on or about October 3, 2020, in Huntington County, Ohio, you knowingly obtained possession using a stick of 2 controlled substances with methamphetamine in violation of section 2925.11 of the Higher Vice Code. So that's the charge. Again, carries a possible prison term between 6 to 12 months, and possible fine of up to $25,000, and possible license suspension 6 months to 5 years. Now, Ms. Dixon, do you understand what it is you get charged with, what the state said you did, when or how they alleged you did it?
Yes, sir.
Have you discussed the nature of the charge, the evidence of the case, the possible legal issues of the case, the possible defenses might try to raise a trial, the possible outcome of a trial with your attorney?
Yes, sir.
And are you satisfied with her advice and confidence?
Yes.
Now, are you under the influence of any type of drugs or alcohol at this time?
No.
Are you taking any prescriptions?
No.
Have any threats been made to get you plead guilty?
No.
Now, other than being promised that if you enter this plea guilty to count 2, and the first count being dismissed, and you would recommend for intervention with a conviction rather than a sentence, finding a guilty sentence, has anyone promised you anything beyond that?
No.
Now, do you hold any license or certification from any state agency for any kind of consultation profession?
No.
And now, you have certain constitutional rights you must understand before accept your plea. First of all, you do have the right to have counsel as having appointed not simply for the purpose of working the case out, but for the purpose of providing any defense that could be available to them in law that you will sure provide. So if you decide you do not want to do this, you'll still be defended, Ms. Hacker, including having a trial if that's what you want. You understand that?
Yes.
The Constitution Dixon, you have the right to have a jury trial, in this case, in which 12 people will be selected from a group of citizens that live in this county to serve on a jury. And after they were selected, the evidence will be presented and then it will be started on the law. And then at that time, then the jury will decide on unanimously on 12 after 3 whether or not the state proves you guilty. Now, if you did not want to have a jury trial, but you do not want to plead guilty, you can waive the right in that context, waive means give up the right to have an attorney, have a jury trial, sorry. And then you would have what's called a court of bench trial. That means that instead of a jury hearing the evidence, it would be the judge hearing the evidence. The judge would apply the law, the judge would decide whether or not the state proves you guilty, prove beyond a reasonable doubt. You understand that?
Yes, sir.
And under the Constitution, you have a right to confront the witnesses against you and cross-examine for your attorney on the court. That means the witnesses against you have to come into this court and testify in front of you and your attorney and anyone else is present. After the prosecution asks you questions, or your attorney asks questions, that's called cross-examination. The purpose of that is trying to bring out evidence that helps your side of the case. You understand that?
Yes, sir.
Under the Constitution, Ms. Dixon, you have the right to use the power of this court to compel or force witnesses to come to court to testify for you, saying to the state. So, if you have witnesses you're not certain will come in voluntarily at your request, the court will issue a subpoena, which is a court order, requiring those people to appear to testify on your behalf if you want them to. You understand that?
Yes, sir.
Now, and again, that's the same way that the state's witnesses are required to come to court. Now, under the Constitution, you have courage against self-incrimination. Ms. Dixon, which means you cannot be forced to give evidence in this matter at any time through the trial. No one can ever make a testimony. The prosecutor can, the judge can, and you decide. And if you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time. No one's even allowed to talk about it except in one situation, that is, if there's a jury trial, you don't testify. The judge instructs the jury that because that's your right, they cannot consider it for any purpose. You understand that?
Yes, sir.
Right now, under the Constitution, you have a presumption of innocence. It means that you're presumed innocent until proven guilty by the state of Ohio on every essential element of the offense charge. So the burden of proof is not on you to try to prove that you're not guilty. The burden is upon the state to prove your guilt by proof beyond reasonable doubt on every essential element of the offense charge, which is the highest burden of proof is known under the law. You understand that?
Yes, sir.
Right now, if you originally pled not guilty plea, denied that you had committed any crime, denied the allegations in the indictment, and it exercises all the rights that I just described. If you change your plea from not guilty to guilty, that is the opposite of not guilty plea. The guilty plea admits the allegations in the indictment, admits their crime that you committed that crime, and that plea waives gives up all the rights that I described for you this morning, except the right to have an attorney. You always have a right to have an attorney no matter what your plea is. But with that exception, your plea of guilty waives gives up the right to have a jury or a court trial. Waives gives up the right to confront witnesses against you and cross-examine your attorney. The Wage gives them the right to supply the court, no force witnesses come to court to testify for you, just like the state. Wage gives up the privilege of self-incrimination because you're saying you're guilty, that's what she finds you guilty. Wage gives up your presumption of innocence because if you say you're guilty, the state doesn't have to prove you're guilty. And it wage gives up any right to file an appeal, which you think you may have had up until this point in the case. Now, if I should sentence you to the maximum sentence under the certain circumstances, you file an appeal, it would have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that?
Yes, sir.
And are you a U.S. citizen, Ms. Dixon?
Yes.
All right, now, do you have any questions about the process of intervention, what's expected of you?
No.
You understand?
Mm-hmm.
Any questions about the charge and possible penalties?
No, sir.
You understand?
Yes.
Any questions about the plea of guilty or what it means, what will happen in that event?
No, I don't.
You understand?
Yes.
Any questions about any constitutional rights of the plaintiff?
No, sir.
You understand?
Yes.
Is there anything you'd like to speak to Ms. Hackner about before we go on?
No.
Do you have any questions about anything that I've explained to you this morning?
No, sir.
That it's your decision, Ms. Dixon, to withdraw your not guilty plea, plead guilty to count 2 in accordance with the terms of the plea agreement that we just gone over.
Yes.
Okay, then as to the charge of count 2, which alleges that on or about October 3, 2020, Huntington County, Ohio, you did knowingly obtain, possess, or use Schedule 2 controlled substance with methamphetamine in violation of Section 292511 of the Ohio Revised Code, the charge of aggravated possession of methamphetamine, 5th-degree felony, and possible prison term between 6 to 12 months and fine of $2,500 and possible license suspension 6 months to 5 years. How do you plead?
Guilty.
All right, thank you. You can be seated. All right, the court finds that on this day of the court, the defendant was advised of all the constitutional rights made knowing, intelligent, voluntary, waiver of sanction 11, lead 7 over 5. The court finds that the defendant's drug dependence and or mental health issues were factors that led to the criminal activity which she had charged, and the rehabilitation treatment was substantially reduced the likelihood of any future criminal activity. She is an appropriate certified treatment program instead of invalid mental health. She is otherwise eligible for control sanctions. She is not a repeated dangerous offender and is otherwise eligible, provided under 2951.041 Revised Code for this program. And as indicated by the stipulated questions that were filed prior to the filing of the motion, with perhaps temporary self-driving. Therefore, the court accepts the plea, but make no finding at this time. Instead, the proceedings are hereby stayed. Defendant shall be placed under the new control supervision of the probation department for a period of 2 years under the program conditions that have been previously approved. Filed record with the court as incorporated as part of this order. The defendant is required to successfully complete an intervention plan to reside in invalid mental health, including the requirement that she must abstain from using drugs and or alcohol for a period of 1 year. She must comply with all the other conditions of the probation department and set up and previously approved by the court, and must pay the court costs of the proceeding as well as any fees that may be charged under the program that she undergoes. Now, if she's successfully completes this plan and pays all conditions of the community control imposed by the court, at that time, the court, upon receipt of that, will dismiss the proceedings against the defendant and set the matter for sealing her hearing. Now, in the event that you fail to complete these treatment or quantitative terms of supervision, then you will receive a written notice of probation, and that will be filed with the court. There will be a hearing scheduled with the representative by an attorney. If the court notifies at that time that you failed to comply, at that time the court could revoke you from this program, find you guilty, and impose a prison term of 12 months, fine you $25, and suspend your license for 6 months to 5 years. All right, is there anything further from counsel? Okay, so you're no longer under pretrial supervision. You'll need to report to the probation department as soon as you get down here this morning, and they'll transfer you over to the new program conditions, and they'll make an appointment for you to have those explained to you and sign for and so forth. Right. Good luck to you. I have a question. Is your father a custodian?
Yeah,
I saw he died recently.
yeah, it held up my, starting my classes and things like that, so I just got started a couple weeks ago, but.
Well, I didn't realize that he was ill, and of course with COVID, I haven't seen anybody for a couple of years, so I hadn't seen him for good while.
Yeah, he's been struggling for about 3 years.
Well, I sent these to you.
Thank you.
All right, thank you.
Thank you.
Okay.
Okay, yeah. Okay, what do you need?
don't have
A hearing notes? No attorney? Financial disclosure? We're on the record, Your Honor.
This is based on the 20 CR 85 State of Ohio versus Ronald D. House second. Ronald D. House on the second hearing. Alright, Mr. House was placed on community control for aggravated possession of methamphetamine. Felony. I don't see the notification there. Did you file your notification, Mr. Walser? When you file? Oh, here it is. Okay. June the 9th. Okay, got it. All right. Mr. Hausman, the court has received a notification that you failed to comply with the conditions of community control, in that Rule 2, you failed to report since October 29th, 2020. Rule 15, you failed to pay your financial sanctions. And Rule 19A, you failed to enroll and complete mental health counseling order. So the court had entered a capias for your arrest back on March 2nd. And so, I'm not sure what we had this delay getting notified, but anyway, you are entitled to have a hearing in this matter, in which the state is required to present evidence to prove that you have failed to comply with these conditions. You have the right to have a reasonable period of time to prepare for the hearing. Usually that's about 10 to 14 days. You have the right to have an attorney to represent you. You can't afford to hire one department for you. Now, in the event that it's found that you have failed to comply, one of three things can happen. I can continue your community control with the same conditions that I previously ordered. I can continue your community control with additional conditions that I think are appropriate. Or the third, most serious, is that I could revoke your community control and send you to prison for 6 to 12 months and fine you $2,500. You understand that? Okay. And I don't have a financial disclosure form here. Are you requesting court appoint counsel for you? All right. Are you employed? All right. Well, you'll need to fill out a form, and I don't have that, but I'm going to assume that. Pardon me? She has. Okay. Well, I haven't received it yet, so definitely you can back it up here. I'm sure it's okay. So I'm going to go ahead and find that you're entitled to appoint counsel and appoint Mr. Harmon to represent you, and we'll set this matter for an evidentiary hearing. You being held on other charges right now, Mr. Howell?
Yes, sir.
Okay, I thought that probably worked. Were you being held somewhere else or in this county?
In Greenville, sir. Didn't I come here, sir?
Okay, when did you get here?
I went to Greenville 7, and 3 years after I come here, sir.
Okay, all right.
I got back in town Thursday, and I was coming to see Drew Monday, but then a whole bunch of stuff happened, and I ended up here.
Okay. Well, we'll set your hearing for July 13th at 2:30 p.m. And I'll appoint Mr. Armstrong to represent you, and you'll be held without bond. All right. We'll notify Mr. Armstrong, and he'll be in touch with you. All right. You have any questions?
Yes, sir.
All right. Thank you.
Thank you, sir.
Okay. 1 o'clock.
1 o'clock, Your Honor.